Today we're talking about one of the most important and sometimes contentious aspects of a divorce, and that is dividing assets. In a divorce, the division of property isn't as simple as just splitting everything right down the middle. Instead, in many states, including here in Georgia, the process follows a concept called equitable division. So what does equitable division really mean? It doesn't necessarily mean equal. Equitable division means that the assets are divided fairly, but not necessarily equally, and it's based on several factors which I'll get into today. That's really the topic of today's video. So we'll talk about marital property versus separate property, and I'll explain how things like real estate, savings, and retirement accounts are handled. So let's talk about types of property. First, it's essential to understand the difference between marital and separate property. Marital property includes assets that were acquired during the marriage, regardless of who earned the money or whose name is on the title of those assets. Separate property, on the other hand, refers to assets that one spouse owned before the marriage or assets received individually through inheritance or gifts during the marriage. In a divorce, only marital property is subject to equitable division. For example, if separate property is commingled with marital assets, such as using money from an inheritance, which would be separate assets, to renovate the marital home, it can sometimes then become marital property. So let's talk about real estate, which is often the largest asset a couple owns. For many, the family home is not only a financial investment, but it holds emotional value as well. Deciding what to do with the home in a divorce, it can be challenging. One common option is for one spouse to keep the home, either by buying out the other spouse's share or by offsetting the value of the home with other assets. For instance, one spouse may keep the house while the other spouse takes a larger share of retirement accounts or other investments. Another option is selling the home and dividing the proceeds, and this can be a cleaner break, especially if neither party can afford the mortgage on their own to be able to keep the home after the divorce. However, this decision depends on the housing market and other financial considerations. So it's important to note that even if one spouse gets the home, they'll also have to take on the mortgage if it's still outstanding, and sometimes they take on a new mortgage if they're taking a loan to buy out the other party. This is a factor that courts consider when determining what's fair in terms of division of assets. Next, let's talk about savings accounts, investments, and other financial assets. These are also subject to equitable division, and just like real estate, they can be divided in a variety of ways. Savings accounts may be split between the spouses, or one spouse may take a larger share of liquid assets while the other spouse may receive more in long-term investments. Investment accounts such as brokerage accounts or stocks, well, those can also be divided, but this can get complicated if the value of these investments fluctuates. So the courts, or perhaps financial experts that are appointed by the courts, or maybe even hired by the parties, will often work to assign a fair value to the accounts as of a specific date, typically the date of separation or filing for divorce. One thing to keep in mind is that capital gains taxes can affect the value of investments. So if one spouse takes on an asset that has appreciated significantly, they could end up paying taxes when they sell, and so that potential tax burden is an important factor in the division of investments, and a CPA or other tax professional can help you work through this. Finally, let's discuss retirement accounts. These accounts, such as 401ks, IRAs, teachers' retirement pensions, civil service pensions, etc., are often some of the largest assets that get divided in a divorce, especially for couples who've been married for a long time. Retirement accounts are generally considered marital property if contributions were made during the marriage. However, the division of these accounts requires careful consideration because they come with specific rules and penalties in a lot of cases. So something called a Qualified Domestic Relations Order, also known as a quadro for its acronym QDRO, is often necessary to divide these assets without incurring early withdrawal penalties. So the way it works is that the quadro is a court order that instructs the retirement plan administrator to divide the account according to the divorce settlement or the order of the court. So like other assets, retirement accounts may be equally divided, or perhaps one spouse may receive a larger share of a different asset in exchange for keeping their retirement intact. This decision depends on the overall financial picture of the couple and each spouse's future needs. It's very, very customized. Every case is different. So what does this all mean? Well, it can mean that dividing assets in a divorce can be a complex process, and it's critical to approach it with both fairness and a clear understanding of your financial situation. It's not just about what you have today, but it's also about planning for your future. So if you're facing a divorce, don't try to go through this process alone. It's too complicated and you only have one chance to get it right. And I see too many people trying to fix a bad divorce in which they were unrepresented, and they either ended up with a very bad settlement or a very bad order from the court. Working with an experienced attorney is essential to ensure that your rights are protected and that you receive a fair share of the marital assets. Find a strong, analytical, experienced attorney who will be your bulldog when necessary and who also won't look to make it contentious. That's the best kind of attorney. One who seeks an amicable resolution but is simultaneously preparing for the battle if it comes to that. When the other side knows that you have strength behind you in the form of a top-notch divorce attorney, they will often be the one looking to settle as amicably as possible. And if they make olive branch statements like, "I don't want us to go to court," don't mirror that language. Just maintain your posture and just calmly tell them, if you're fair and equitable, we won't have to go to court. But my attorney and I will be simultaneously preparing for court in case you aren't fair in settlement negotiations. And that, my friend, is fairness through strength. In the military, they talk about peace through strength, right? Well, in divorce court, I talk about equitable, fair division through strength.
Thank you very much.
Hey, thanks for watching. Be sure to click subscribe, like, follow, and turn on the alerts so that you'll get notified when we post our newest videos. And please share these videos, leave us comments, and ask us questions. Also, join our Facebook group, Georgia Divorce in Custody, and I'll see you again on the next video.